Welcome to this unit on the fundamental basics of various economic laws. Here, we'll delve into key legislation designed to regulate financial transactions, curb financial crimes, and protect India's economy from illicit practices. Specifically, we'll explore the Prevention of Money Laundering Act, or PMLA 2002, the Benami Transactions Prohibition Act of 2016, FEMA 1999, and COFE-POSA 1974. Our economic laws primarily serve three purposes: to regulate financial transactions, curb financial crimes, and secure India's economy from illicit activities. Let's begin with a closer look at one of the most significant, the Prevention of Money Laundering Act of 2002, or PMLA. This act came into force on July 1, 2005, following its introduction as a bill in 1998, driven by UN resolutions against narcotics, corruption, and terrorism. The PMLA's core objective is straightforward: to prevent the conversion of illegally obtained money, often called black money, into seemingly legitimate assets. It's important to note that money laundering under PMLA is a serious criminal offense, carrying a minimum imprisonment of 3 years, up to 7 or even 10 years for drug-related offenses. To truly understand PMLA, we need to grasp the concept of money laundering itself. At its core, money laundering is the process of taking illegally earned money and making it appear legitimate, or claiming that property derived from criminal activity is, in fact, untainted. This complex process typically involves 3 distinct stages. First, there's placement, where the illicit cash or dirty money enters the financial system. This is often the most vulnerable stage for being detected. Next comes layering, which involves a series of complex transactions, sometimes internationally, designed to separate the illicit money from its original source and obscure its audit trail. Finally, we have integration, where the laundered money is returned to the criminal from a seemingly legitimate source, such as a loan or a property purchase, allowing them to enjoy the proceeds of their crime. 2 other crucial concepts under PMLA are proceeds of crime and scheduled offenses. Proceeds of crime, or POC, refers to any property, whether directly or indirectly, derived or obtained from criminal activity, linked to a scheduled offense, or the value of such property. Speaking of scheduled offenses, these are specific crimes listed under various acts that trigger the applicability of PMLA. They are categorized into Schedule A, which covers offenses under 29 specific acts, Schedule B, covering offenses under the Customs Act, and Schedule C, which includes offenses with cross-border implications or willful tax evasion under the Black Money Act. It's important to note that offenses under the Income Tax Act and GST are not currently covered as scheduled acts under PMLA. The primary investigating agency under PMLA is the Enforcement Directorate, or ED, which possesses significant powers. These include search and seizure, allowing them to enter and search premises, break locks, seize property or records, and even examine individuals under oath if they have reason to believe an offense has occurred or proceeds of crime are present. The ED can also provisionally attach property for up to 180 days if they suspect a person holds proceeds of crime that might be concealed or transferred. For arrests, high-ranking ED officers, deputy director and above, can arrest individuals suspected of money laundering, provided they have approval from a special director and inform the grounds of arrest. Finally, beyond criminal liability, any proceeds of crime are also subject to confiscation by the government. Now let's shift our focus to the Benami Transactions Prohibition Act of 2016. Historically, Benami transactions were actually legal in India, even recognized by courts and the Indian Trust Acts. However, there's been a significant shift. What was once permissible is now a criminal offense carrying severe penalties. So why did people engage in Benami transactions historically? Motivations ranged from defrauding public revenues or creditors, avoiding other laws like land sealing acts, hiding transactions for various reasons, deploying corruption money, or simply distancing oneself from the real transaction and its implications. The legislative journey of the Benami Act is quite interesting. An initial Benami Transaction Prohibition Act was formulated way back in 1988 with the aim to curb black money. However, for 28 years, it largely remained ineffective due to a lack of proper machinery provisions and rules. The real change came with the 2016 Amendment Act, which dramatically expanded its scope, moving from just 9 sections to 72, introducing rigorous penalties and establishing the necessary enforcement authorities. A crucial development then occurred in August 2022 when the Supreme Court ruled that the Act is applicable only from November 1, 2016, effectively quashing any proceedings initiated prior to that date. Let's delve into the core definition of a Benami transaction. It's essentially an arrangement where property is transferred to or held by one person, known as the Benamidar, but the money for that property, or the quote, consideration, is provided by another person. Crucially, the property is held for the immediate or future benefit, whether direct or indirect, of the person who actually provided that consideration, who we call the beneficial owner. For a transaction to be officially considered Benami, all three of these, quote, limbs must be fulfilled. The Act broadly identifies four categories of Benami transactions. First, the most common, property held by one person, paid for by another, with the benefit for the payer. Second, transactions made in a fictitious name, meaning a non-existent or fake person or company. Third, where the person in whose name the property is held is unaware of or denies knowledge of such ownership. Think of property held in the name of a driver or servant. And finally, when the person providing the consideration, the beneficial owner, is not traceable or is also fictitious. It's important to understand what constitutes Benami property. This includes any property involved in a Benami transaction or any proceeds derived from it. This definition is broad, covering movable, immovable, tangible, intangible, corporeal, and incorporeal assets, as well as rights, interests, and even legal documents. The consequences of engaging in Benami transactions are severe. It's a punishable offense, carrying rigorous imprisonment from 1 to 7 years, along with a fine of up to 25% of the property's value. Critically, the property itself is subject to confiscation by the government, without any compensation to the owner. Furthermore, the Act prohibits the right to recover any property held as Benami, and it also prevents the Benamidar from retransferring that property. However, even if the three core criteria of a Benami transaction are met, there are specific exceptions. These include property held by a Karta or co-partner of a Hindu undivided family, HUF, provided it's from known sources of the HUF. Also, property held in a fiduciary capacity by individuals like trustees, guardians, executors, or company directors, if for the company's benefit, is exempted. Furthermore, property transferred in the name of an individual's spouse or child, paid from known sources, is not considered Benami, and notably, joint ownership is not required here. Lastly, property transferred in the name of a brother, sister, or lineal ascendants/descendants from known sources is also exempt, but only if it is held in joint ownership. Finally, let's explore the Foreign Exchange Management Act of 1999, or FEMA. This act significantly replaced the much more controlling Foreign Exchange Regulation Act, or FARA, from 1973-74, which primarily focused on conserving foreign exchange. FEMA, in contrast, was enacted with a philosophy of liberalization. Its aim is to facilitate external trade and payments and to promote the orderly development and maintenance of India's foreign exchange market. Essentially, FEMA governs all foreign exchange dealings, covering everything from the import and export of currency to overseas remittances and foreign direct investment. A crucial distinction is that FEMA is a civil law, unlike its predecessor FARA, which carried criminal liability. Therefore, violations under FEMA are considered contraventions, not criminal offenses. Thank you.